Are you serious?
Time to get back to Radio Law Talk on RadioLawTalk.com and on your favorite radio station. Radio Law Talk.
So the Weinstein case is supposed to be, the trial's supposed to begin January 6th. And one of the witnesses is slated to testify against him on allegations. Again, these are all allegations stating that he had sexually assaulted her. And this person supposedly has gone through what's called, quote, suggestive psychotherapy to help recover memories of her alleged assault. This is, again, I always call it a can of worms. This is a huge issue as to whether or not, these are true memories or someone's suggesting these memories. And there's an individual professor at a University of Nevada, Reno, that has testified multiple times on this issue where she discusses these memories and whether or not it's basically what we call false narrative, how trauma or a situation they believe they were in trauma, these recovered memories are really not true memories. And basically what they've said is Weinstein's trying to get this individual professor to testify, and the prosecutors are saying no. Now, let me bring up one other thing before we get into this.
Well, Weinstein's first trying to exclude the testimony of the witness,
right,
and then secondly, be able to call their own expert
if she comes in.
If she gets to testify.
Yeah. What is interesting is this individual coming in from University of Nevada, this the expert that Weinstein's trying to get in, argues that sex that is undesired, but that the person chooses to engage in it, what she will testify to basically is this leads to distorted memories. And so that comes up right to this individual that's claiming sexual assault. So there's a federal and a state law in determining or standard to determine what type of expert is allowed to testify. And Todd's going to differentiate between the two because don't forget, there's a federal and a state court going against a New York federal case and a state case going against Weinstein.
Yes, and so anytime you see somebody in the law really fighting to want to have a case in a certain jurisdiction, or they want let's do it in this state versus the other state, if there's like a bunch of different states that they can try the case in, what we're going to talk about here is why it's important. Okay, in New York. Now, let's clarify here. The trial coming up in January is for the case that Weinstein is facing in New York State Court, being prosecuted by the Manhattan District Attorney. This is a state court case, not a federal case. He does have a federal case that's in New York, but that's put out a little bit, okay? And so Weinstein wants to call this expert. So what's the standard? What does the court have to look at before it will allow an expert to testify? And there's a case out there called Fry that was used by a lot of states. On the federal level, the U.S. Supreme Court has said Fry does not apply. We use Rule 702. But in New York State Court, the Fry rule applies, and the Fry rule is this. The court looks at the proposed testimony and looks at the qualifications of the expert and then asks whether the scientific techniques used by that expert are generally accepted by other scientists as reliable. And the DA is arguing that the expert put forward by Weinstein, the expert that's going to come in and testify that memory isn't as rock solid as you think that it is, and is going to talk about this concept of unwanted, what did they call it?
Unwanted sex.
The unwanted voluntary sex. So I don't want to do it, but I'll agree to do it. Why, that's not rape, but somebody who thinks about that can morph it into rape in their own mind. And the DA is saying there's no such thing as unwanted voluntary sex. If you have sex and you don't want to have sex, it is rape. And okay.
No comment, right?
No comment, but I'm guessing that years and hundreds of thousands, millions of people who've been married would say, look, there are times when one partner wants to and the other partner doesn't, and they have it, and nobody is raped. It's just somebody agreed to and somebody didn't, because as we were saying, it's only going to take 2 minutes out of your life anyway.
Anyway, what is Todd anyway?
So that's the concept here, and they're going to fight it now.
But that's an actual fact. Even though we talk about
Yes.
this stuff, this is true. This is what this case is stemming on.
That's right. Weinstein is going to argue that everybody that I had intercourse with agreed to have intercourse with me. If they later regretted it or wanted to do something, that's one thing, but it's not rape. That's his defense. Not saying it's a winner, not saying it's a loser. That's his defense. And this expert has testimony that will help his defense. And in a state case, the standard is, are there other scientists that agree with this? In the federal case, though, it's different. In the federal case, it doesn't rely on what other scientists would say. The federal standard for that evidence coming in is whether the expert's scientific, technical, or other specialized knowledge will help the jury, the trier of fact, understand the evidence to determine the issues. That's one. Two, the testimony has to be based on sufficient facts or data. You can't just pull stuff out of thin air. Three, the testimony is the product of reliable principles and methods. Now, it doesn't say reliable because other people say it. The expert can say, yeah, it's pretty reliable. I use it all the time.
And it's my
And it's
test,
mine. It's my test.
and I've
It's
done
what
this,
I use.
and I've done this analysis, and et cetera, et cetera.
Well, I don't know if you guys remember this, but back in the late 80s, the early 90s, there were false memory syndrome type cases. That is where adult children were having recovered memories, and they were accusing their parents of child abuse. I actually was one of the first out of 33 in the nation to successfully defend that case and successfully defend the parents, because their daughter had gone way too far into this. She had had recovery, and she did therapy during the recovery, and they did suggestive techniques in therapy. And she then believed that she absolutely had been a victim of serious cult-like satanic ritual abuse by her parents, and she believed it. She was a medical doctor, 40 years old.
Wow.
So what we had to do to protect the parents is we had to tie out all these false memories that she had to different books she had read, and also to show that it couldn't possibly have happened. One of her allegations got her, and that was that she claimed her parents drilled a hole in her forehead. So I got the judge to order an x-ray. And the judge deemed that it wasn't, to go too far into it. Got the x-ray back, no hole in the forehead. I won the case, and my clients have actually received money.
Hey, I think Todd and I would lose those cases for sure, because we have multiple holes in our head.
Yeah, but they're all naturally occurring.
Yes.
This is there's something that's referred to oftentimes as the Mandela. You ever heard the Mandela effect? The Mandela effect refers to it first came about when people would start to talk about, oh, yes, Nelson Mandela. I remember when he died in the 80s and how terrible it was and the funeral that was on TV and everything like that. Yeah, Nelson Mandela is still alive. He was still alive at the time.
Yeah.
The comedian Sinbad.
Yes.
Yes.
How many of you remember seeing the show Shazam or Kazam where he played a genie? Yeah, Sinbad was never in a movie called Kazam where he played a genie. But there are people that believe that all the time. And it is this idea that through suggestion, people will remember things that don't happen. And that's what's really caused this scientific technique to really gain ground and get legs, because people will remember things. Police interrogations are questioned all the time when they say things and suggest things to defendants who end up committing or admitting stuff, confessing to stuff that scientifically they could not possibly have done. Folks that are exonerated through DNA evidence that confessed to the rape back in the day, it's because of the suggested nature of questions.
Exactly.
And you say something
Wanting
enough
to please the investigator, too.
Exactly.
Say
And so,
what they want.
So these memory experts, I do believe, have a place coming in. The extent to which they can testify and what will be allowed in remains to be seen. And Weinstein's got a battle, though, in New York, given the fact that they use the Frye standard.
Yes.
Let me tell you. Go ahead.
Sorry. Doesn't California use the Kelly-Frye standard?
They do?
Now, Kelly is a little piece of it, too, right?
Yeah.
It's different than
Kelly is essentially the California Supreme Court case that uses Frye, which is a Supreme Court
What
case.
I'm trying to say is I think if they do not allow this expert to come in, and yet this other individual gets to testify that had suggestive psychotherapy, appeal, take it to the Supreme Court of New York. I bet you, I can't bet, but I think it's going to get overturned. That's just not right, not fair. You're going to allow someone to come in that had suggestive psychotherapy, and you can't put an expert up to discredit them? No? Really? Okay. We're going to be back, talk more about Alec Baldwin, and then we're going to talk a little about Ellen DeGeneres and her celebrity friend, Sandra Bullock, making